Bom dia a todos, meu nome é Leonardo Nemer Caldeira Brant, eu presido o Centro de Direito Internacional com sede em Belo Horizonte. É com muita alegria que eu saúdo a todos os presentes, saúdo igualmente os professores internacionais e nacionais que irão estar conosco durante essas 2 semanas, durante o 16º curso de Direito Internacional. Eu gostaria de dizer que, em primeiro lugar, esse curso foi todo desenhado num novo modelo online. Nós já estamos aí no 16º curso desse gênero. Ele foi totalmente adaptado às novas circunstâncias, o que, de certa forma, permitiu também uma extensão do número de participantes, de professores internacionais e nacionais participantes. Temos este ano 19 grandes nomes do direito internacional que estarão presentes conosco durante essas 2 semanas. Num primeiro momento, portanto, eu gostaria de agradecer a todos os professores que colaboraram conosco, que estarão conosco nesse período, com palestras muito interessantes sobre temas dos mais variados do direito internacional. A todos eles, o meu muito obrigado. Em segundo lugar, saúdo e agradeço também aos alunos, aos estudantes que estão participando neste período de julho, conosco durante essas 2 semanas. O nosso também muito obrigado. Esse é um curso que envolve uma grande equipe do Centro de Direito Internacional, a qual eu tenho o imenso orgulho de colaborar e de presidir. Ele é um curso que pretende trazer para o Brasil e para a nossa América Latina o mesmo modelo de cursos que, de forma quase centenária, já é uma tradição nos países europeus e nas principais universidades do mundo. Portanto, para nós, uma grande satisfação que tenhamos ele já há mais de uma década no Brasil. O curso de inverno de Direito Internacional, com toda a sua abrangência e extensão, não seria possível de ser realizado igualmente se não fosse a relevante parceria e a confiança e o apoio da Fundação Konrad Adenauer no Brasil. A ela estendo um caloroso agradecimento e tenho a certeza de que estamos contribuindo juntos para os valores do direito internacional, para os valores dos direitos humanos, para os valores do Estado Democrático de Direito, para os valores da democracia e, com certeza, para a compreensão e construção de um mundo, de um universo internacional mais justo e mais equilibrado. Portanto, agradeço de forma calorosa ao apoio da Fundação Konrad Adenauer no Brasil. Gostaria, portanto, de dar início ao 16º curso de inverno de Direito Internacional, esperando que todos tenhamos 2 semanas de muitas atividades e aprendizado. Um forte abraço a todos.
I'm very happy to have you back, and it's a pleasure again to receive Professor Pierre Dajan. I'd like to address my warmest welcome to Professor Pierre Dajan. Professor, thank you.
Thank you very much, dear colleague Luis. It's a pleasure to be back, ladies and gentlemen. Today I will cover the intrinsic modalities of international obligations. You remember that yesterday I covered the extrinsic modalities by distinguishing between bilateral obligations and collective obligations. And let me just remind you that the extrinsic modalities of international obligations are not simply about the relationship between the bearer of the obligation and the corresponding right holder. The distinction between bilateral and collective obligation goes beyond that. It's a distinction that is more broadly about the legal interest that exists in requesting compliance with the obligation. And that legal interest is broadened in terms of the subjects that may request compliance when we meet a collective obligation, whether it's an erga omnes obligation or an erga omnes partes obligation. And within erga omnes partes obligations, we made the distinction between integral obligations and interdependent obligations. And as I said yesterday, the emergence of collective interests in international law is really a turning point in the construction of the legal order for the world. It's really the passing from a legal order concerned with coexistence to a legal order concerned with cooperation between states and taking over global concerns. Now, I would like to turn today to intrinsic modalities. And the intrinsic modalities of international obligations concern the way in which the obligation binds the subject that owes the performance of that obligation. And it is important to identify the intrinsic modality of each obligation, because it will help us to determine what counts as a breach of the obligation. The breach of an obligation being defined in Article 12 of the Articles on State Responsibility, being defined as an action or an omission that is not in conformity with what is required by the obligation. Well, to know what is required by the obligation is therefore important. And my submission is that, of course, every obligation is different. And of course, you need to interpret the rule that contains the obligation, or that contains various and several obligations, because the different obligations may be contained in the same rule. And when you interpret the rule, you will discover those obligations. And of course, this is a matter of interpretation according to the various rules that apply to the various instruments of international law, the various norms. And my submission is that this interpretative exercise of discovering what the obligations are under the rule does not occur in a mental vacuum. My submission is that we have some kind of mental framework that will guide the interpretation, and that will end up finally into deciding whether the obligation is a positive or a negative obligation, or if it is an obligation of conduct or an obligation of result. And my submission is that at the end of the day, all those interpretations will lead to somehow finding that the obligation is either positive or negative, or of result or of conduct. And knowing, as I said yesterday, that when you combine, you can have only negative obligations of results, while you can have positive obligations of result or of conduct. And I will explain what's the difference between an obligation of result and an obligation of conduct. And I'll turn to that. But this is my submission, and my submission is that this typology and the difference between positive, negative, conduct or result really reflects very basic human behavior. As we know, states are abstract entities. As we know, international organizations are abstract entities also, but of course they behave, their conduct is the result of human behavior that needs to comply, to conform with what is required under the obligation. And this issue of conforming with the obligation will always lead to having to decide what type of behavior is required by the obligation. And my submission is that the behavior, the human behavior of the agent of the state or the agent of the organization will be either an abstention or an action, positive or negative obligation, or it will be an obligation, and combined with that, it will either be an obligation to try to do the best you can, or an obligation to achieve something, okay? And it can be achieving something by abstaining, or it can be achieving by doing something, okay? And let me come to that. But those distinctions, I think, really reflect, again, law is common sense, okay? Law does not grow outside of common sense, and it always relates to human relations and to human behavior, okay? And when you go to the substance of it, well, what do we do in life? We either do things or don't do things. And we either do things in order to achieve something that is required, or we do things the best we can. And those are degrees of behavior, in a way, differences in terms of behavior. Let me take first the distinction between positive and negative obligations. And I will first try to explain the distinction, and then I will give you a few hints in the law of state responsibility to explain why the distinction, I think, is important to make. A positive obligation is an obligation that is violated, breached, by a failure to act. Either the failure to act is total, somebody must do something but doesn't do anything at all, or the failure is only partial. You do something, but you do not do something enough, okay? You should have done more, okay? In both cases, the wrongful act, the conduct that is in breach of the positive obligation will be what is called an omission, okay? It is an omission. You fail to do something that you should have done. By contrast, a negative obligation is an obligation that is violated, breached by a positive conduct. That is something that you can observe in the real world, okay? For instance, if you have an obligation not to kill, well, killing is the breach of the negative obligation not to kill, okay? So a negative obligation is an obligation to abstain from doing something that is physically possible, okay? But you ought to abstain from behaving. For instance, the obligation not to commit genocide is a negative obligation. The obligation to prevent genocide is a positive obligation. You have to do something to prevent genocide from occurring, okay? Or, for instance, the prohibition of complicity in genocide, okay? There's also a prohibition of complicity. That is a negative obligation. And if you turn to the Serbia case to which we referred to yesterday, you will see that difference. For instance, at paragraph 432, the court says that the obligation not to aid and assist in the commission of genocide is a negative obligation. Okay, so that distinction is very, very basic. Actually, it is already reflected in Article 2 of the Articles on State Responsibility. When Article 2 says, let me bring it to you. When Article 2 of the ILC, you know the draft articles on state responsibility, when it says that there is an internationally wrongful act when the conduct consisting of an action or an omission, okay, the conduct is either an action or an omission. The conduct is an action or an omission. The violation of the obligation consists either of an action or an omission, because the obligation is either an obligation that is negative and the breach results from an action, or the obligation is positive and the breach results from an omission. Okay, that is very basic. Okay, and you have millions of obligations that are either labeled as positive obligations or negative obligations. Some people have doubt that the distinction makes sense. Some people have said, well, you may have a positive obligation hidden in a negative obligation, or vice versa. And it is true that when you look at certain rules will imply, okay, if they are a positive obligation, they will imply a negative obligation also, okay? But those nevertheless are different obligations. There is an interplay between positive and negative obligations stemming from the same rules. But those obligations are distinct nevertheless, because what consists of a breach of those obligations will either be an abstention, an omission, or a conduct, a positive conduct that you can see in the real world, okay? And despite this, and for instance, again, to take the Bosnia-Serbia case, in the Genocide Convention, there is no prohibition for the state not to commit genocide. There is no such rule in the treaty as such, okay? However, there is a rule that contains a positive obligation, which is the obligation to prevent genocide. And of course, if states have an obligation to prevent genocide, it is because they may not commit genocide themselves. And the court made that very clear. But the prohibition of genocide binding on states is constructed, is derived from the interpretation of the positive obligation. So there is an interaction between the two. Likewise, in human rights law, many positive obligations have been derived, some people say created by the judges, have been derived from negative obligations. And yesterday I mentioned the prohibition of torture, for instance, the protection of the right to life, and the prohibition of extrajudicial killing. Those rules that are labeled as negative obligations will also contain positive obligations, will be derived from those positive rules, from those negative rules. Negative obligations. In human rights law, the distinction between positive and negative obligations has also been criticized, contested, and people have suggested that the distinction should be replaced by a trilogy that you know very well, which is the distinction between the obligation to respect, to protect, and to fulfill human rights. And I think this, those verbs are very interesting because they encapsulate, they describe more precisely what is required from the state. But those verbs are not by themselves obligations. They are not, they simply describe what the state should endeavor to do, and they simply want to point at the fact that there is a continuum in human rights law from negative obligation. The obligation to respect is usually considered as a negative obligation. To protect and to fulfill will reflect positive obligations of the state, including when the behavior of other individuals is at stake. There is an obligation to protect human rights from the interference of private actors, okay? And I think this is very useful analytically but this does not replace the fundamental distinction between positive and negative obligations, in the sense that a breach of an obligation will always consist either of an action or an omission. So despite the criticism, I think, that has been addressed to the distinction between positive and negative obligations, I think you always fall back on that distinction when you have to assess whether a breach has been committed or not. Because in order to know if a breach exists or not, you have to know at what type of behavior you have to look at, whether the behavior is an omission or an action. So I think the distinction is pertinent. And by the way, the distinction is made in the case law of the ICJ, for instance, and in the case law of human rights courts. Okay, so I think it is inescapable that we always fall back on those basic differences. Now, what I would like to draw your attention to is that the distinction between positive and negative obligations has a bearing in the law of state responsibility, at least in regard of three important things. The first one being the question of attribution. You know that in the law of state responsibility, much has been said about attribution of conduct to the state. States are abstract entities, organizations also, they behave through human beings. And deciding whose conduct, the conduct of which human being is attributable to the state is a very important matter. And we discussed yesterday the case again of Serbia and whether the conduct of the Bosnian Serbs is attributable to Serbia or not. And of course, rules on attribution are rules that somehow convey the understanding of what is a state, or also the understanding of what is an international organization. They relate to the subject, okay? And subjectivity, whose conduct is attributable to the abstract entity. Well, when you think about it, the distinction between positive and negative obligation is very important in terms of attribution. Because strictly speaking, when it comes to a negative obligation, you will indeed have to attribute, to impute a conduct in the real world that is by somebody to the state. And the rules of attribution have a lot of importance in that regard. There is the conduct of somebody, the conduct, the action, which allegedly is in breach of a negative obligation. And in that case, you will need to attribute that conduct through certain rules of international law, secondary rules of responsibility, to the state. When it comes to a positive obligation that is breached by an omission, a failure to act, actually, you will never apply rules of attribution as such. You will identify the state bearing the obligation, and you will simply see if there is an omission or not. But you will not as such attribute an omission. And if you look at the case law, that's very clear. If you look, for instance, at the hostage case, the case between the United States and Iran concerning the hijacking of the US embassy in Tehran at the time of the Iranian Revolution in 1979, 1980. Well, there is a failure to act, okay, on behalf of the authorities of Iran. They did not protect, as they should have protected, the premises of the embassy. There's a big debate in that case about whether the conduct of the students, the Islamic students that stormed and occupied the embassy, a big debate about whether that conduct, which is an action in violation eventually of a negative obligation, whether that conduct is attributable to Iran or not. But there's another obligation, which is an obligation to protect the diplomatic premises. And for that obligation, there is no discussion of attribution whatsoever. There is simply the court identifies the obligation, determines that the obligation is a positive obligation, that the breach of that obligation exists because Iran failed to do anything, okay? But strictly speaking, there is no attribution. There is just the identification of the obligation bearer, the state owing the positive obligation. So when you face a positive obligation in terms of litigation, the only thing that you have to demonstrate is that the state owing the obligation did not do what the obligation requires. But you don't have to do anything else. You identify the obligation and the state bearing the obligation, and that's it. You don't come into a debate about whether, if there is an obligation, if there is a positive obligation, there is somehow in international law a presumption that it is for the state to fulfill the obligation. Whoever is acting or not acting doesn't matter, okay? The failure, whether it is the legislature, whether it is the government, whether it is a state organ or a person that is instructed by the state, it does not matter. There is a failure to act, okay? And who was supposed to act never comes in the picture in terms of attribution. So, and when, as I said, sometimes the omission is only a partial omission. Yes, the state acted, but it didn't do enough to comply with the positive obligation. Well, in such a case, in a litigation, the state will claim the behavior as being its own behavior. Okay, the state will say, oh no, I fulfilled my obligation. Look at what I did. Okay, so the state is owing the attribution. The state, it's the debtor, the respondent state will say, well, this is my conduct and I did what I had to do. So there again, the attribution will not be controversial because the state will be claiming attribution for itself. What the claimant state will say is simply, well, maybe you did something, but you did not do enough. And there is still an omission, partial omission, that constitutes a breach of the positive obligation. So, of course, and when you read the work of the ILC on attribution, you will see that the Commission says that a state is responsible for actions or omissions, and omissions are attributable to a state. They are always attributable to a state, but you never discuss attribution of an omission. That it's nonsense. You just identify the duty bearer, and that's it. Okay, and that's why it is important to know if you are facing a positive or a negative obligations. It has a repercussion in terms of attribution. First. Second, the distinction is also important in terms of cessation of the breach, because when you are facing a negative obligation, cessation of the breach, if the breach is ongoing, requires simply putting an end to the wrongful conduct, okay? Which means that you have to stop doing what you are doing, okay? Cessation of the breach of a positive obligation is almost undistinguishable from the actual performance of the primary obligation. How do you seize the breach of a positive obligation? you seize that breach by complying with the obligation. And you have to perform. Because performing a positive obligation is action, okay? So you have to actually behave in the way required by the positive obligation. And that makes the cessation of the breach very similar, if not identical, to the performance of the obligation, okay? If the obligation is still binding, of course. While for a negative obligation, you have to stop doing what you do, which also is complying with the positive with the primary obligation. But there you can see in the real world that you simply stop doing something. Okay. Let me turn to the third issue, which is more tricky, and it's the issue of causality. Causality under the law is always controversial and is always a very legal matter. And you know that in international law, causality is probably more tricky than under domestic law because we have less cases and we have less practice. And but there is still the requirement that the injury results from the breach, okay? And that the obligation to make reparation is only triggered for the responsible state of the breach if the breach caused the injury, if from the breach the injury ensured. Now, when you look at negative obligations, those are obligations that are breached by a conduct in the real world that you can observe, okay? For instance, the prohibition on the use of force, to take a basic example, or for instance, the prohibition of torture, okay? If a state uses force, you can see that in the real world. If a state tortures a person, you can see that in the real world. And the assessment of causality will be rather straightforward, okay? You can see, materially speaking, something flowing from the breach. You can see a territory being invaded. You can see houses being destroyed. You can see a person suffering from injuries, physical injuries or mental injuries. So the causal link is fairly easy to establish, and to establish on the basis of, you know, the sine qua non test, the but-for test. Were it not for the breach, the injury would not have occurred. That's the basic, so elementary causal test, okay? But when you are dealing with a negative obligation, that appears very clear. If it were not for the invasion, the house would not have been destroyed. If it were not for the torture, the person would not suffer mental injury. That's very easy to establish. Sometimes it's more complicated because there is an issue of remoteness. There are in the causal chain, there may be numerous interactions, and we know that the case law has developed the requirement that the injury be direct, or that the injury be proximate, the proximate injury, or the requirement of proximity, or the foreseeability of the injury in the normal course of events. And those criteria are very important because causality under the law is not causality in the physical world. Okay, most of the time when we face negative obligations, it will be the same causality and causal assessment, but not necessarily so. And to take an example on the use of force, both, for instance, in 1947 in the peace treaties with Italy, Hungary, Romania, and Bulgaria, or in the United Nations Compensation Commission that was established after the Iraq War of 1991, in both cases, you have a lot of case law that has been stretching the causal link from the illegal aggression to the injury, but including to the injury that has materially resulted from the military action of the Allied powers. Okay? So a bomb falls from an American airplane. That airplane destroys a military objective on the ground. Materially speaking, it comes from the action of the American forces. However, from a legal point of view, the reasoning is such that without the Iraqi invasion of Kuwait, the Americans would not have engaged in a war authorized by the Security Council. Therefore, it was foreseeable that if Iraq did not withdraw from Kuwait, a military action would result. And it was foreseeable for Iraq that the United States would use military power. Okay, so this is causality in legal terms. Okay, you stretch the causal link from the breach, from the initial breach, and you cover with causality the behavior you attribute, not in terms of conduct, but in terms of causality, you attribute an injury to Iraq, while the injury, physically speaking, was not the result of Iraqi action, but of the action of the Allied powers. Okay, so that's why causality under the law is very different from causality in the real world. But when you face negative obligations, it usually is fairly straightforward, okay? Because you can see things in the real world. When you face positive obligations, obligations that are breached by an omission, then when you apply the sine qua non test, when you apply the but-for test, things become extremely hypothetical. You have to imagine, to establish causality, and this is what the court required, the ICJ said in the Bosnia case, you have to imagine the situation that would have resulted if the state had complied with the obligation. So you have to imagine something that never occurred in order to assess whether the injury that occurred would not have existed. So it's very, it's amazing what we have to do under the law. We have to imagine a past that never existed, imagining whether the present would have changed. Okay, and it's very difficult. It's an hypothetical counterfactual that is very difficult to match. And at the end of the day, it will be a human judgment. And at the end of the day, somehow, it amounts to how much do you think that the positive obligation is capable of changing the real world? Okay, that's at the end of the day, that's what the judge will have to assess. Okay, oh, there is an omission. Had the state done, if the state had done what it had to do, would the world have been different? Which means, is the positive obligation so much commanding on reality? Okay, is it so much a tool for a change in the real world? Or is the real world so complex that other elements, you know, would in any case have led to the same outcome? And that's what the court had to assess in the Bosnia-Serbia case. Okay, had Serbia behaved properly in preventing the genocide? Had Serbia done everything it could have done? Would the injury still exist or not? Okay, and the court said, I'm not 100% sure. Maybe if Serbia could have done more and complied with its obligation, the genocide would nevertheless have existed. Therefore, there is no causal link. Okay, So it's a pure mental assessment. There is nothing in terms of material causality, nothing at all. It's a judgment on what and how the world could have been if what did not happen would have happened. Okay, so it's extremely abstract. But again, the level of abstraction when we face the breach of a positive obligation is much higher than when we face the breach of a negative obligation. And I submit that very often when people analyze causality, they, under international law, they fail to make that distinction between positive and negative obligation, and they fail to understand that the but-for test in a positive obligation context amounts to a very hypothetical counterfactual. Okay, and therefore maybe we should be thinking about another test, another causal test when it comes to positive obligations. But so far the case law is very is very limited, and it's very difficult to determine. Now, let me turn, I see that the time is flying. Let me turn to the distinction between obligations of result and obligation of conduct. Yesterday, there was a question put to me, an interesting question by a student, I'm sorry, I don't remember her name, saying, well, if a state has the obligation not to interfere in the the domestic affairs of another state, and because I said they cannot be, in my opinion, a negative obligation of conduct. In my opinion, that does not exist. Okay, you remember the table I made when yesterday when I shared my notes, I showed you that in my opinion, you cannot have a bilateral, you cannot have an obligation or a negative obligation that is an obligation of conduct. Okay, you remember that. Let me share that again to you. And she said, well, isn't that a negative obligation of conduct? The obligation not to interfere in the domestic affairs of another state. Well, I submit that this is not an obligation of conduct. It's an obligation of result. Okay, of course, it's an obligation that requires a certain conduct, but the distinction between obligation of result and obligation of conduct means something else. And this is what I want to bring to you this morning. What is this distinction? The distinction comes from the French legal system that exists in Roman law or in other Roman law systems. It's the distinction between l'obligation de moyens et l'obligation de résultat. Obligation of means, if you want, obligation of conduct, or obligation of result. An obligation of result is an obligation to succeed. It's a very strict obligation. You have to reach a certain outcome. You have to be, in each time you have to behave. Okay, there's a conduct each time, but you have to succeed in achieving a certain result. For instance, you have to succeed in not using force, or you have to succeed in. You may have positive obligations of result. Okay. And the obligation is breached by not attaining the expected outcome. The state will usually be free to choose the means that it wants to choose in order to achieve the result. But the result it must achieve. And that's an obligation of result. An obligation of conduct, in contrast, is an obligation to do the best you can. Not necessarily, not necessarily achieving the result, but at least doing the best you can to comply with the obligation. The obligation of conduct is a positive obligation to try, an obligation to endeavor, and it's breached by the failure to act with due diligence. Okay, and the distinction is important because obligations of result are strict obligations. The obligation is breached because the result is not achieved. When you have to prove the breach of an obligation of result, the claimant has an easy task. The result is not achieved. When you have to, for instance, the prohibition on the use of force, I'm sorry to fall back on that. It's not simply, I did my best not to attack my neighbor. No, that will not be a good legal excuse. Okay, you should not, okay, attack your neighbor, full stop. And the result is expected from you. The result being a world where war does not occur. When we face an obligation of conduct, the burden of proof on the claimant will be more difficult. The claimant will have to prove that either the respondent did not do anything, okay, because it's a positive obligation of conduct. It's always positive obligation. So if you didn't do anything, that's easy, okay? There is a complete failure to act. But if there's a partial omission, you will have to show that what was done was not enough. And the question will be, what is the enough? What should have been done, okay? And the obligation of conduct will be an obligation that will vary over time. What you can do in 1920 is not the same as what you can do in 2020, okay? Because knowledge has improved, for instance, because the capacity to act has improved. The same obligation will change over time. What is required to comply with the obligation will over time be evolving. And that's why obligations of conduct are very useful in terms of negotiating a treaty, okay? Because you know that this obligation will, the due diligence obligation will evolve over time. There's a debate to know whether due diligence evolves and is different from state to state, whether you're a developing state, you don't have the same means as a rich nation. And my understanding of obligations of conduct is that indeed obligations of conduct, because they're required to do what is reasonably possible for the state to do, due diligence, this will vary in time, but in space also. What the United States can do is not the same as what Burkina Faso can do, okay? And certain obligations of conduct, of course, will have to be assessed differently in light of the various duty bearer. So it's an instrument that it's a type of obligation that gives in international law a certain flexibility, okay? And therefore also increases debates, claims, contradictory claims of states. But it's a distinction that exists in positive law. And if you look at the case law of the ICJ, again, you will see the distinction between obligations of result, obligations of conduct. In the International Tribunal for the Law of the Sea, you will see the two advisory opinions of 2011 and 2015, where the ITLOS Tribunal also refers to obligations of conduct and obligations of result, and characterizes certain obligations as being obligations of conduct rather than obligations of result. And the distinction between the two what makes an obligation of result or an obligation of conduct is a matter of interpretation, but of the rule containing the obligation again. But the main reason for distinguishing is the issue of risk. Is there a risk? And is the duty bearer facing any risk? And the risk may result from nature, because states cannot control everything, because natural processes exist, or the risk results from the conduct of individuals. Okay, for instance, in investment law, the obligation of full protection and security that the state owes to the investor. Well, full protection and security is to a certain extent an obligation of conduct. The state must do everything it can to physically protect the investment, like for an embassy, okay? It's an obligation of conduct. There are some situations in which a mob, a crowd, will be overtaking the protection of the state. Even if the state did all it could, posted soldiers and policemen, that was not enough, okay? And the state may have complied with its obligation of conduct, and nevertheless, the embassy would have been invaded by the crowd, okay? And the risk exists because the behavior of third parties are at stake. Behavior that is not attributable to the state itself. So there was yesterday a question also about soft law. And I think here I'd like to take that question and to illustrate in relation to illustrate soft law and the role played by soft law in relation to obligations of conduct. If we take the pulp mills case between Argentina and Uruguay, you remember it was about the construction by Uruguay of pulp mills along the river, that is the border between the two states. In that case, in order to determine whether Uruguay complied with its obligation not to pollute the Uruguay River, which the court will determine to be an obligation of conduct. One question arose about the construction of the pulp mills. And because Uruguay has an obligation to do all it can to prevent the pollution, Uruguay has the obligation to use the best available technology and to require from the pulp mills that they use the best available technology in the process of producing pulp for the production of paper. So there is an obligation of conduct, says the court, but in order to assess whether the obligation of conduct is complied with or not, the benchmark that will be used to know whether Uruguay acted with due diligence, the benchmark that will be used will refer to soft law. And the soft law in this case being a document issued by the European Commission. Okay, so between Argentina and Uruguay, you will refer to a European Union document about the best available technology for the production of pulp mills. Of course, that document is not binding on Argentina and Uruguay. It's not even binding in EU law. It's just a standard, an industrial standard of production for pulp mills. And it is the best available technology. Today, at the time, maybe in 50 years, it will be a very polluting or considered to be very bad and polluting technology. But today, it is the best available technology. So in order to assess whether Uruguay complied with its due diligence obligation of conduct, the court will see if the best available technology was used by Uruguay in the pulp mills. And this is done by referring to a soft law instrument. But an instrument that will have a great importance, of course, because where do you, okay, due diligence means doing everything you can, reasonably everything you can. What does that mean concretely in terms of industrial standards? In order to do that, to know what it means, you look at the industry, the best available technology at the time, okay? And that is the interplay between a positive obligation under the Uruguay Treaty, Uruguay River Treaty, that's a 1975 treaty, which the court characterizes as an obligation of due diligence, an obligation of conduct. And in order to give concreteness to that obligation, the court will use a soft law instrument, okay? Not transforming the soft law instrument into hard law, okay? Because the hard law is only the obligation under the treaty, but to give concreteness to that treaty obligation. What was good for the court in that case was that both Argentina and Uruguay agreed between themselves that the European Union document was the good reference, okay? The question, and therefore for the court it was easy using that document. The question you can ask yourself is, what would have happened if the two countries were not in agreement about using that soft law instrument? What should have done? What would the court, how should the court have reasoned the case? And my submission is that the court should have, also have to look around at the best available technology, interpreting the due diligence obligation to the fullest, and requesting from Uruguay to comply, not with, a lower standard, but to comply with the best available technology at the time. And the court, I think, would have had to do the same. And the best available technology was this technology used in the European Union, and specifically in Finland, where a lot of pulp mills are being produced. So this interplay between soft law and hard law is very interesting when it comes, and very much at play when we talk about obligations of conduct, okay? But again, we have to be careful not transforming the soft law into hard law, okay? There's a bridge between the two because the due diligence criteria for the obligation of conduct, for the performance of the obligation of conduct. Now, a subcategory, and I will finish here before taking your questions, a subcategory of obligations of conduct are obligations of prevention. The obligation to prevent is a specific type of obligation of conduct. It's an obligation of conduct because it is also a due diligence obligation. It's also an obligation that must be performed by doing the best you can, but not necessarily by achieving the result. As the court said in the Bosnia case, of course, the obligation to prevent is triggered before the event to be, before the occurrence of the event to be prevented. But that obligation is only breached if the event to be prevented occurs. Okay, so it's a tricky obligation. It's an obligation that is triggered prior to the event, of course, because you have to prevent it. Okay, but it's an obligation that requires to do all you can to prevent the occurrence of an event. But it is only if the event occurs that you will be able to know whether the prevention duty has been breached or not. Okay, and it is no excuse to pretend that the event would have occurred anyway, even if you did everything you could have done. Okay, so it's a very tricky obligation, and let me refer you to paragraph 430 of the 2007 judgment of the ICJ in the Bosnia-Serbia case. So I see it's already 1 hour that I've been lecturing. Again, it's very intense. I'm sorry, it's very abstract to a certain degree. But let me bring back this table of combination. We have to look at obligations in terms of combining those dimensions, those modalities. The obligation might be bilateral or collective, and if it is bilateral, it can be a negative obligation of result or a positive obligation of result or a positive obligation of conduct, and likewise for collective obligations. And again, to a certain degree, I fully agree that those modalities or this typology is very abstract and very how to say, does not make justice to the full diversity of obligations. Okay, there is an immense diversity of obligations. All obligations are different. However, and to come back to the essential, however, all obligations will, at the end of the day, you will be able to discern the most important elements of those obligations through that typology. And I think the typology is performing, in the sense that the typology helps us to interpret rules, to find obligation, and also the typology helps us to better identify the legal regime, notably in terms of responsibility, the legal regime flowing from the breach of an obligation. So that's what I wanted to convey to you today. Thank you very much for your attention yesterday and today. And of course, I'm in your hands for questions that you may have. Thank you.
Thank you, Professor. It was again fantastic. We have questions here. We'll begin with the question of Rodrigo Franco. He asks, Professor, would you say that the obligation of non-recognition as presented in the RCWA is part of customary law? And which is the nature of such obligation? In your typology, do you think it is possible to regard an obligation of non-recognition in Palestine versus USA, ICJ 2018? Due to its general nature, even though there is no mention about in the Palestinian petition. I think that's the first one. We have another 4 that can be combined. Do you think it's better do all together, or this first one and then?
Let me take this first one then. Let me take the first one. Okay.
Okay.
As to the obligation of non-recognition, as understood under RCWA, it's an obligation, it's a secondary obligation that flows from grave breaches of peremptory norms. It is, I think, indeed a customary law obligation. It is not an obligation. I mean, it can be imposed by the United Nations Security Council, and we have seen in the practice that the UN Security Council has imposed such obligation not to recognize. For instance, if we take the Turkish Republic of Northern Cyprus, or if we take the Republika Srpska of the Bosnian Serbs, there you will find a clear obligation binding on all member states not to recognize. Otherwise, I think the ICJ has said that both in the 1971 advisory opinion on Namibia and on the continued presence of South Africa in the Southwest Africa, or in the Wall advisory opinion, that the duty of non-recognition exists under general international law, that is customary international law. I would characterize that obligation as a collective obligation which is a negative obligation of result. Because it's a collective obligation, because I think the interest in requiring compliance with the obligation lies in all states. All states are bound by such obligation, and all states have a legal interest in requiring compliance. So, for instance, if a state recognizes the Turkish Republic of Northern Cyprus, it is not only Cyprus that has interest in contesting that behavior, it's all states, because of the peremptory nature of the rule that has been breached. First, it's a collective obligation, I would submit. Second, it is a negative obligation. It is obligation not to recognize as legal. And so states have a duty to abstain from recognizing. I don't think that states have a positive obligation to do something or to contest. They simply have an obligation not to recognize. And it's an obligation of result in the sense that, you know, something is expected from them. And what is expected is simply not to recognize. It's not a best endeavor obligation. It's not a due diligence obligation. So that is for the how to, you know, apply my typology to that specific obligation, which is interesting, by the way, because it shows that the typology also applies to secondary obligations in international law. It does not only govern the understanding of primary norms, primary obligations, but it also applies to secondary obligations. Now, to come to the case that was brought by Palestine against the United States, I'm not involved in that case. I think it's an interesting case. However, I see one issue in that case, which is the fact that the case is brought under the 1961 Vienna Convention on Diplomatic Relations. There are no diplomatic relations between Palestine and the United States. The instrument under which the dispute is brought is an instrument that is supposed to regulate obligations between states that have diplomatic obligations. Now, it might be the case that some of the obligations that Palestine claims that the United States has breached, it might be the case that some of those obligations under the Vienna Convention either are customary international law obligations also, but in any case are obligations that apply irrespective of the existence of diplomatic relations. This being said, when you look and simply the title of the 1961 Vienna Convention, it is the Vienna Convention on Diplomatic Relations between States. So there's an issue of, you know, is the instrument applicable in the relation between the US and Palestine? Full stop. Okay. And I'm not sure of that. I guess it's an issue that the court will have to address. I'm sure that the United States will raise the issue. Of course, you know, it's a very delicate dispute, and it might be a way out for the court. However, the dispute is not premised. I don't remember precisely. I've read at the time, I have read the application from Palestine, but I'm not sure that the dispute is premised on the violation of the obligation not to recognize. I don't remember that precisely. So the other obligations have allegedly been breached by the United States, but I don't remember that Palestine makes, but I may be wrong on that. I'm sorry, it escapes my memory. But that's what I would say for that first question. Thank you.
Thank you, Professor. The second round, we have questions about environmental law from Jean Ferreira and Bruno de Souza. Could you please talk about soft law and principles as the main source of international environmental law? I think you already talk about soft law, but they want to talk about international environmental law and soft law.
Yeah. I'm happy to do that with the caveat that I'm not a specialist of environmental law at all. Well, at all, even if I've been involved in environmental law cases. I think, of course, you know, I mean, the classification of an instrument as being soft law very much depend on what you take as being your theory of the sources of international law. Okay, we go back to that. I am a fairly classical international law lawyer, so I am, in that regard, you know, very orthodox, and I am fairly conservative in the sense that I would classify certain instruments as not falling within the theory of sources. It doesn't mean that they are not important and relevant. They are, of course, they are important and relevant. States sometimes spend month and month and month of negotiating instruments that pretend not to reflect or not to bind them. Okay, sometimes those instruments will nevertheless reflect certain existing obligations. They will contain, you know, obligations, but obligations that exist under general international law, customary international law rules. And in soft law instruments, you will find a reference to some of those rules. Now, the instrument as such will not be binding, but it refers to an obligation that is binding under a usual process of lawmaking under international law. And other parts, and the difficulty will be to distinguish within the soft law instrument what is really law or what is really a repetition of law and what is not, and what is an incentive to move forward. I think we must remain always extremely careful when we say, "Oh, this is law and this is hard law." I mean, this is an assessment that is extremely important, and we must make sure that what we say is correct, because we don't want we want states to continue. You know, it's important that they sign soft law instruments. It makes them move forward. Okay, so we don't want to discourage states from doing so, from inventing, you know, soft law instruments that allow them to have some guidelines. You know, that it gives them a certain horizon. It's not binding, but it's not really important that it is binding. It's a political way forward, and if we trap states by saying, "Oh, this is binding on you," well, next time they will do nothing, and we don't want to end up in such a situation. So and that is why I think it is important to be prudent. Some people will say conservative, to be prudent when assessing the bindingness of those instruments, but they are of course important, and I think they are most useful when they interplay with obligations of conduct, as illustrated in the Pulp Mills case. That is a very interesting, I think, and probably most illuminating interplay between hard law and soft law that you can imagine. So that's why it's important to keep the flow of soft law occurring. And in order to keep the flow of soft law occurring, we really have to treat it for what it is and not for what it is not. That's what. But in environmental law, soft law has historically played a role precisely because states. I mean, we face a field where the interaction between the behavior of private actors and the behavior of states, between human behavior, globally speaking, and natural events, is such that there's a lot of, reluctance to bind yourself strictly. Okay. But nevertheless, there is a social need to regulate or to approach common problems with common lenses and analytical tools, and that's why soft law has been so much developed, I think, historically speaking, in environmental law. And it has, I think, over the years, produced some hard law results. Yeah, certainly. That would be my answer.
So now, human rights. Marina Maha asks about how can human rights law and positive obligation help with the protection of healthcare personnel and vulnerable patients in the COVID-19 pandemic. And she also asks about the Max Schrems. I really don't know how to pronunciate the surname of Max correctly, but why did the judgment of the European Court of Justice in the case of Schrems established that the European Commission needed to adopt a more active approach in examining whether a third country, such as USA, provides for an adequate level of protection if it was the USA who breached the positive obligation? Those questions are from Marina Maha.
Okay. On the second question first, on the Schrems case of the European Court of Justice, it's a recent case. I'm not sure everybody is aware of it. I have not read the case yet. I've heard about the case in newspapers, but I have not read the case. It's a judgment that relates to the protection of privacy and private data of European citizens that is shared with the United States under certain agreements in terms, when you take a plane to the US and things like that. I don't know the details of the case. Okay, so I'm not going to comment on the details of the case. But one thing I can say is that the reason why the European Court of Justice has quashed European law instruments, and including instruments that give effect to treaties concluded with the United States, is because the European Court of Justice has the authority to annul, invalidate European Union acts if they do not conform with the Charter on Fundamental Rights. And so the European Union legal order stems from international law because it's based on treaties. But at the same time, as the European Court of Justice has said time and time again, it is autonomous from international law. It establishes itself as a separate legal order, and it defines by itself how it interplays with international law in a very similar way to the way that domestic legal systems interact with international law. It is for each domestic legal system to determine to what extent international law applies internally, okay? And for international law, it doesn't make any difference. I mean, you breach your obligations, but there is in every state a certain degree of dualism between domestic law and international law. The same is true for European Union legal order. European law is separate from international law, and the conformity of European Union Act with the basic treaties and the Charter of Fundamental Rights is a matter of hierarchy of norms within the European Union legal system. So, and of course, the European Court of Justice has no power of adjudication vis-à-vis the United States of America or any other third country. Of course not. It's a domestic court. It's an internal court of the European Union. But again, the details of the Schrems case, I could not comment. But it is quite usual for the European Union, for the European Court of Justice to quash decisions or acts of the European Union. It's a classical, constitutional court that looks at the validity of certain acts in light of superior norms, and those norms being the fundamental treaties on the European Union and the Charter on Fundamental Rights, which have some constitutional value, if you want, in the European Union. On COVID-19 and human rights, I'm really at a loss because I'm not sure I understood the question, and I'm not sure I could really comment on human rights aspects. There is certainly some human rights issues involved. The right to health, of course, is at stake in this debate, and in the typology between obligations to respect, to protect, or to fulfill. It certainly is a positive obligation of the state. I don't think that we could characterize the right to health as an obligation of result. And by the way, in domestic law, this distinction between obligation de moyen, obligation de résultat, obligation of conduct, obligation of result, stems from medical practice. In French law, a doctor has no obligation to cure you. Doctor only has the obligation to, be a good doctor and do everything he or she can to bring back good health. But good health is such a there is so much at stake, so many different elements intervening, and medical science is not a perfect science, that the outcome is always uncertain in certain regard. Now, you could say, and the domestic case law in every country has evolved. Okay, some very mundane medical treatment can be considered today as an obligation of result. Okay, some basic mundane things, that very routine stuff that every doctor should perform properly. But for the rest, it's not an obligation of result. It's an obligation of conduct. And I would say that the human rights obligation of the state to provide its citizens with the best possible health care, or to protect the health of its citizens, is an obligation of conduct. This being said, we fall back on the issue of, did the state do everything it could in its own power to actually indeed protect the health of its citizens? And there might be some failures. Okay, there might have been some reluctance. There might have been obvious omissions. Okay, failure to act. And it's not because it's an obligation of conduct that it's a meaningless obligation. On the contrary. But to pretend that the state must make sure that none of its citizens is going to die would be stupid. Okay, this is certainly not the case. and government would stop. You know, if that is what is required by the law, then nobody wants to engage in any sort of politics anyway, because you will fail, of course. There will be, but anyway, and if you think about it, it's probably in terms of social contract, when you fall back on the philosophy behind all that. Saying that it's a due diligence obligation is something very strong. It means that the state has positive obligations to do everything it can, and it's and to engage with the protection of the health of its own citizens. But honestly, I'm sure that there must be some. I think there is a UN special rapporteur on the right to health. I'm sure that person will have a lot to say about the COVID-19 crisis. And it will be interesting to read the reports and to read from the reports how the special rapporteur understands the obligation to protect the health of citizens and the right to health. That's what I would say.
Thank you, Professor. Now we have one from Amanda Lemos. She asks, in the Nicaragua case, the ICJ applied the effective control test for attribution, positioning itself against the overall control test applied by the ICTY in the Tadic case. Would you say the court was correct in applying a more strict test, or still did not dive in establishing proper attribution itself? And there's one more from Talia Paceto. The distinction between interdependent and integral collective obligations can only be determined if the norm expresses the legit response to the breach of the obligation, or it can be determined even if the norm is silent about that. So that's the two last questions.
Yeah. Okay. Thank you very much. The Nicaragua case, yes, I mean it's a classical instance of fragmentation of international law, where we have one court applying a certain rule for attribution, the ICTY with the overall control test, and the ICJ applying the effective control test. By the way, the court in the Nicaragua case in 1986 developed the effective control test, and later came the Tadic case of the ICTY, but then in 2005 and again in 2007, and very specifically in 2007 in the Bosnia-Serbia case, but already in a way in the Uganda case, DRC Uganda case, the effective control test was reaffirmed by the court. So it's really a matter of who do you consider as the authority, the ultimate authority to assess rules of customary international law. Is it the ICTY or is it the ICJ? I think, I mean, the case law, I think, is settled. It is effective control, and there's no going back from it. We have to accept the ICJ finding for what it stands. It has been repeated, it has been criticized, and the court fell back. I think it very much reflects the idea that states are responsible for what they do, okay, for what effectively they do. So it's also, I think, a criteria which suits states very well. Okay, I fully understand the criticism that is addressed to the effective control, because the burden of proof that results from such attribution criteria is nearly impossible to meet. Okay, how can you, and most of the time those are covert operation, those operations where a state, you know, gives weapons, you know, or gives finance to groups, etc., etc. So it's a criteria that somehow allows states to do their dirty business easily and getting away from it, with it. Okay, they do their dirty business and they get away with it easily. At the same time, it's a criteria that prevents the making of certain arguments that would be extremely destructive of the world. Look, for instance, at if it was the overall control test, you would unquestionably be able to say to Iran, you are responsible, you Iran, you are responsible for what the Hamas is doing or what the Hezbollah is doing in all parts of the world. The aggression by Hezbollah is the aggression by Iran. So I am Israel, I'm going to bomb you, you know. I am the United States, I'm going to bomb you. So in terms of self-defense, the overall control test would have catastrophic results because it will allow immediately to consider that you are under the law of self-defense, under Article 51 of the UN Charter. It would allow you to say this is the aggression of that state. It is the conduct of a group, that the group is controlled by the state and therefore it's attributable to the state and therefore I can go and bomb. So in a way, you know, the overall control test is in today's international community at the same time something that would allow of course, to find states responsible for their dirty business, but at the same time, it could very well result in catastrophic outcomes because it would give some very powerful actors even more power to display the use of force around the world. So we have to, when we criticize the ICJ for what it did, we have also to understand all the facets of the rule. That's what I would say. Now, on interdependent integral obligations, I think you do not need the norm to be explicit. Those are doctrinal categories. You will not find in a treaty saying, hey, by the way, this is an integral obligation, or hey, by the way, this is an interdependent obligation. It stems from the system of the treaty, from the regime in which the rule is embedded. It's, I think, a matter of interpretation, and it really is on the it is for the interpreter, including the states parties to the instrument, and sometimes it will be very obvious, okay, that this is a rule, this is an obligation that is of an independent character or an integral character. When it relates to human rights instruments, for instance, of course, those are integral obligations. They must be obeyed, they must be complied with, irrespective of whether the other side complies or not. And vice versa for interdependent obligation. When it makes no sense for you to continue performing your obligation, if the other side does not perform, you can stop performing vis-a-vis all other states, parties to the instrument. So it will be a matter of interpretation, for sure. And sometimes it might be a matter of evolution. For instance, if take the Whaling Convention. the whaling convention, is that an integral obligation or is that an interdependent obligation? It really depends on if you consider that whales are something very special in nature that needs to be protected. But you may say, you know, if it's an interdependent obligation, well, Japan is fishing, I'm going to kill whales also. Okay, if they don't do their part, I'm not doing my part, which is very bad for the whales. So you might, but there's some logic. There is some logic in it. So you might end up saying it's an integral obligation, which you know, very much depends on what value do you assign to the object of the treaty. And that is what is interesting with the classification. It's because it brings us back to, you know, assessment of values. What do we consider as being important and how important it is, in which way it is important. So this classification triggers all those type of questions, which are very often silenced by the rules, okay? And it's for the interpreter to make them clear and to give weight to the obligation. So that's my answer.
Thank you, Professor.
I saw that it's already 8 minutes.
No, don't worry. It's all wonderful. I think it was wonderful for the students too. It was for me. I'd like to thank you again. And hope we will see each other in the future, presently or remotely. Thank you.
Thank you very much for your kind words. It was a pleasure, ladies and gentlemen, to address you yesterday and today. And thank you very much, Luis, for your kind words. I was very pleased to meet you also, and I'm sure we'll meet again. Thank you very much.
Thank you. Bye-bye.
Bye.